Hi, thank you for using My Court Coach. I'm Jaylin and I'm going to be your instructor. DV-120, Response to Request for Domestic Violence Restraining Order. So that's the form that we're going to be reviewing today. So the name of the person asking for protection, it's going to be the moving party. And then your name, you would be the restrained party or the alleged abuser. If you have an attorney, you're going to list their name, their information here. If you're trying to keep your information confidential from the other party, then you can go ahead and do that by just listing a mailing address. You don't need to provide your telephone number, fax, or email. But if you have an attorney, the attorney does need to list those things. So you're going to use this form to respond to the request for the domestic violence restraining order, and you're going to fill it out and take it to the court clerk. Have the person in one served by mail with a copy of this form and any attached documents, so you can review our video about the DV-250. And this form is for response to a restraining order request. And the judge will consider your response at the following hearing, and that hearing is going to be on your DV-109, the notice of court hearing, and you do need to write the date, time, and department or room number of your restraining order hearing. And it says to obey the orders in form DV-110, temporary restraining order until the hearing. At the hearing, the court may make restraining orders against you that could last up to 5 years and could be renewed. So you must obey the orders, and the court may make restraining orders against you that could last up to 5 years and could be removed. So that we just wanted to repeat that to have you understand the seriousness of the restraining orders, because sometimes individuals just think, well, whatever, I'm just not going to appear. I don't care if she or he gets the restraining order granted against them or against me, and so be it. So it could last up to 5 years, and to not know what could happen between now and in 5 years if the court grants it, and it might affect your employment. That's something that you definitely want to consider, so please talk to an attorney about that. But for purposes of filling out this form, you do need to verify the relationship that you have with the person that's asking for protection. And so this is actually one of the ways for you to defeat the restraining order, is if the other party is like your coworker and they're claiming that they had an intimate relationship with you and you didn't have an intimate relationship with your coworker, then you can go ahead and say that I don't agree with the other party and I have had a relationship that's listed on their request for a domestic violence restraining order because, and you can just say they're simply a coworker and we've never had any intimate relations or something like that. So that is one of the ways to defeat the response to a request for a domestic violence restraining order, is just by the relationship, and that other person now has the burden to show that you did have that relationship. So you do need to be prepared to respond to that. If you do and you're just saying that just to get out of it, you would need to verify or at least defend yourself in a way that this relationship did not exist. And if they're showing proof of some romantic conversations between you and the other party, it's going to be up to the judge's discretion to believe who is the more credible person and whether that intimate relationship did exist with your coworker, which would then allow for this restraining order to proceed as scheduled. So other protected people, so you can agree that the other people that are protected on the restraining order can continue to be protected on a more permanent restraining order, or you don't agree that they would be protected and you would agree to some other alternative. And if you have a different arrangement that you would want for these other people to be protected, then you can go ahead and ask for it here. It's very rare that there would be a different arrangement unless that is like your children. If it's your kids and you're asking for supervised visitations then, or, well, yeah, supervised visitations would actually be the best response to that if they were your kids. Although this is not the area to talk about custody and visitation, but if they are your kids and you're saying, well, I don't want them to be protected, but I would agree to supervised visitations, then that would be an appropriate response for number 5 here. And it says specifies your reason in item 25, page 5 of this form. You can do that, or you could also attach this MC025 and just write DV-120 and the reasons why you don't want the other protected parties on the request for a restraining order to be protected. Now, personal conduct orders. So you agree to the orders requested or you do not agree to the orders requested. And if you don't agree and you have a different arrangement that you would like to propose, then you can go ahead and request that. And maybe a different arrangement can be that you want a mutual personal conduct orders in place. And personal conduct orders are the equivalent to no negative contact. So the harassment and the stalking and all of that, those sort of contacts are negative. And so therefore you want no negative contact. And so you can request that the proposal would be both ways, that we both do not have contact with one another. But however, the court is likely to not be okay with that because the restraining order is against you and not the other party. And a lot of individuals, when are in pro pers, at least when they go to court, they think that that's their time to show the court how bad the other party is and how they've been abusive to them. And the court only response is, you know, ma'am or sir, you didn't file a restraining order against the other party. And so we're not here to talk about what he or she did to you. We're here about what you did to them. And so in that circumstance, you better have filed a restraining order if you're also trying to get a mutual stay away from each other or no negative contact or anything, you know, like that. So, and you could also use that as a strategy, as a way to respond to the restraining order, is to have personal, or to have a new restraining order filed against the other party. And then you could also file this response in addition to that. And you could say, I would agree to the order that's listed in my request for domestic violence restraining order. So it just depends on, again, your personal circumstance and how you are going to respond to the action. So a stay away order. So if you're staying 1 yard, 100 yard, whatever, how many yards away from the other party, you would need to either agree to it or don't agree to it or offer some sort of solution. A move out order is either you agree to continue being moved out and not going back to the residence, or you can say, I do not agree to the order requested, but I would agree to. And perhaps your request would be, well, okay, fine, I'm okay to not go back to that residence, but I would go ahead and agree to the other party allowing me to go and obtain my stuff from the residence over a course of a day or something like that. So you can offer those solutions. Any guns or firearms. So if you do have any guns or firearms, it tells you that you have to turn those guns and firearms in your immediate possession or control. You have to file a receipt with the court from a law enforcement agency or a licensed gun dealer within 48 hours after you receive the temporary restraining order. So you definitely do not want to show up to your restraining order hearing not abiding by this law if you do have guns or ammunitions. So, but if you don't have guns or ammunitions, then you don't have to worry about it. If you're asking for an exemption, then you can go ahead and ask the court to provide you with that exemption. So you can ask for an exemption from the firearm prohibition under Family Code Section 6389H. And let's just review that law together here. So the court may, as part of the relinquishment order, grant an exemption from the relinquishment requirements of this section for a particular firearm if the respondent, or the person that's the alleged abuser, can show that the particular firearm is necessary as a condition of their continued employment, and if the current employer is unable to reassign the respondent to another position where a firearm is unnecessary. If an exemption is granted pursuant to this subdivision, the order shall provide that the firearm shall be in the physical possession of the respondent only during the scheduled work hours and during travel time to and from the place of employment. When a peace officer is required as a condition of their employment to carry a firearm and whose personal safety depends on the ability to carry a firearm, a court may allow the peace officer to continue to carry a firearm, either on duty or off duty, if the court finds by a preponderance of the evidence that the officer does not pose a threat of harm. Prior to the court making this finding, the court requires that a mandatory psychological evaluation of the peace officer and may require that the peace officer enter into any counseling or other remedial treatment program that deals with any of the propensity for domestic violence. So all in all, if your job does require you to carry a firearm, then the court can exempt you from it, if and only if your employer cannot put you in a position where you do not need or cannot be using the firearm during the duration of this restraining order. And then if you are a peace officer, then the court can allow you to carry it regardless of whether you're on duty or off duty, because it's part of your personal safety. But they have to find by a preponderance of the evidence, and that burden of proof is fairly easy to, overcome. So especially if you do have to go through a psychological evaluation. And if that psychological evaluation comes out in your favor, then you're essentially beating that preponderance of evidence because you're showing to the court that you don't really pose a threat of harm. But if you do undergo the psychological evaluation and you fail it, then the likelihood of you being exempt is very slim. So I have turned in my guns and firearms to law enforcement, or sold them to or stored them with a licensed gun dealer, a copy of the receipt showing that I turned it in or sold it or stored my firearms. And you can show whatever that receipt is that's been attached, or if you've already filed it separately with the court, you can certainly do that too. And you just need to make sure that they check that box. But please make sure that this area of your response is in fact addressed and completed. So record unlawful communications. You can agree to that order requested, or you can not agree to the order requested and request something else. And it's very rare that the court would not allow for unlawful communications. So you should always say that you don't agree to the order requested, period. But realistically, the court would grant that even on a domestic violence restraining order hearing, unless the other party doesn't want to record you. The care of animals. So if there is a request to care for the animals and you don't agree to that, then you will be checking off B. If you do agree to that, then you can go ahead and check that off. And I think a good time to check off I agree to the order requested, if it's not your animal, you don't take care of it, and you don't really care for it, then just go ahead and agree that they can have exclusive use and possession of that animal and care for it and all of that. And you could even take it a step further and say, well, I don't agree to the order requested, but I would agree that they have exclusive use and possession of it. Because when you do agree to an order requested, you're agreeing to the restraining order against you, but that you wouldn't be able to be around those animals. But it's just much easier to just say that I would agree that the other party keeps the animal and has exclusive use and possession of the animal, versus saying I agree to the order requested. So this is where it's good to talk to an attorney about what is best for you. But the better practice, in our opinion, is to just do 11B. especially if you don't have, a relationship with this animal and it's not yours. Just say I would agree to the exclusive use and possession or control and possession of the animal to be given to the other party. So child custody and visitation. So you agree to the order requested, you don't agree to the order requested, and you have to identify why. You're not the parent to the children listed on the request for child and visitation, or you're asking for a different child and custody and visitation order, and that you do or do not agree to the orders requested to limit the child's travel as requested in DV-108. So depending on your specific circumstance, you're going to fill that out accordingly, asking for a 50-50 custody schedule when you have committed some sort of domestic violence act or the other party is suggesting that, or you're seeing pictures or photos of the bruises or markings on the child's body that's been submitted to the court against you, and then you're asking for a 50-50 custody, and you have to be really realistic in that regard. So if you are not guilty of committing domestic violence against the children, then please make sure that you are clicking on 12B. And if there is a no travel with children order, then make sure that you also check this box as well. And it also says that you and the other parent may tell the court that you want to be the legal parents of the children, and that's the agreement of judgment of parentage. So if you and the other party are not married, but you are in fact the legal parent of that child, or want to be the legal parent of that child, then you can go ahead and ask the court to enter that as the judgment of parentage, which is probably one of the quickest ways to get the judgment of parentage, and ironically through a restraining order. However, if you win the restraining order, then that judgment is no longer going to be in effect, because essentially the whole entire case goes away. So the court would actually require you guys to complete a paternity action in order for it to enter a judgment for paternity. But if there is a restraining order granted against you and you're going to agree to the judgment of paternity, then the court can in fact do that. So for child support, you're either going to agree to it or not agree to it, or agree to pay guideline. And the best practice is to always say I do not agree, or you can say I can agree to pay guideline child support. I think that actually makes the other party who does have children look better if they do need to pay guideline child support, depending on the calculations, and that's something that you can do with an attorney. So whether you or not you agree to pay support, you have to fill out the FL-150 form. Realistically speaking, there has never been a child support order that's been granted at the time of the restraining order hearing. There's just no time for the court to hear that or to go over the finances. They'll go over the custody and visitation, maybe if you're lucky. Otherwise, they just keep the orders that's already in place in the temporary restraining order, or modified a little bit. So now it went from no visitation to supervised visitation, for example. But if you don't complete the FL-150 or the FL-155 by the time of your restraining order hearing, nothing's going to happen, because there is not going to be enough time for a child support hearing. So you can just say I don't agree to the order requested, and perhaps you'll go through Department of Child Support Services or negotiate with the other party about a child support amount. It's always best to, appear before the judge in the best possible light that you're doing these sort of things to take care of the children, regardless of a court order, even if it's you paying a nominal amount of like $50 or something. So that would be our suggestion with respect to number 13. And you could even list that in your response, that you're in agreement with paying, $10, $50, whatever it might be to the other party per month. So property control, you agree to the order requested or you don't agree, and then rewrite your response. Debt payment, the same thing. Property restraint, the same thing. Spouse support, the same thing. And it also asks you to complete the income and expense declaration, likelihood of the court granting that on your restraining order hearing is very, very slim. So I wouldn't worry about completing the income and expense declaration for spouse support. But again, just keep in mind that you always want to be in the best light in front of the judge when they are making these support orders. And then rights to mobile device and wireless phone account. So you can agree to it or don't agree to it. If this is an account that is in fact, in your name and you're okay with releasing the phone number and the mobile device, then you might as well, go ahead and do it. But if you're not okay with it, then you're going to just say, I do not agree to the order requested. And if you have some alternative solution, then you could go ahead and propose it there. Insurance, this is particularly true if the parties are married and you don't have to agree to it, but the court is definitely going to order it regardless of whether you agree or not. But you can say you don't agree to it, and you can list why in your reasoning, or you could state that you would agree to some other way of handling the insurance. A lawyer's fees and costs, you can agree to it or you don't agree to it, and you could write out what you do agree to. And then you could also request that the other party pay your attorney's fees and costs, and you would need to complete an income and expense declaration. Again, that would not be addressed at your restraining order hearing, but that is something that you would and can address at a later time if you win your restraining order. So if you defeat the restraining order and the court denies the moving party the restraining order, then you have to have had this box checked in order for you to file a motion to request attorney's fees, and you definitely have to file an income and expense declaration so that the court is able to apply the appropriate law to order attorney's fees to what they call a prevailing party. Now, payments for costs and services, you can either agree to that or not agree to it, or offer some other solution. The better intervention program, you can agree to it, not agree to it, or offer some other solution. Another solution, that you could do aside from that is, let's say you go to individual counseling or something like that. That could be an alternative to the better intervention program that you could suggest, and hopefully you avoid having to do the better intervention program. The court will not decide it on the day of your restraining order hearing because, again, they don't have time to go into that depth. But I have seen the courts grant it on a restraining order hearing, and that's only because you're not there, you're not at the hearing, or maybe the facts are just so grave against you that the court feels that this is just an absolute must, that they have to order the better intervention program, and the restraining order is probably going to be granted for 5 years at that point. So typically it's not handled at your restraining order hearing. Very rarely do I see it handled at your restraining order hearing, but it can, depending on the factual circumstances that's being presented to the court. And then any other orders that the other party is requesting, you either can agree to it or not agree to it, or propose something else. Out-of-pocket expenses, you're going to ask the court order payment of out-of-pocket expenses because a temporary restraining order was issued without enough supporting facts, and the expenses are, and you type up the item, the amount, and all the other items and amounts, and then you fill out your income expense declaration with respect to that. So reasons that you do not agree to the order requested. So you can use this entire section or just say see attachment and use this attachment right here and just complete several of these and just attach them one after the next. Or if there is enough information to write out everything that you want to write, then you certainly can do that too. Make sure you identify the number of pages that is going to be attached to this form, and you're going to type up, your name and the lawyer's name if you do have one. You do need to complete this form and serve it by mail. It's 2 calendar days before the hearing. That's typically what it is. But it's not like the court's not going to accept it if you file it the day of. Of course, you do risk the court rescheduling the hearing because the other party is now bombarded with all of this information at the time of the hearing. They just need more time to review it. So it's wise to just serve it prior to your restraining order hearing, so that you don't, especially if you don't want the hearing to be rescheduled. I hope that this helps, and best of luck.